I've given this lecture a couple of times at the invitation of the university, and I always enjoy doing it, meeting with students and trying to impart a little knowledge about patents and intellectual property, because I think as engineers in an engineering discipline, you're going to encounter these issues if you haven't already. They're going to be at the forefront of many of the endeavors that you're going to pursue once you graduate and you work at an engineering firm or at a large corporate firm making products. So it's a major concern for them, and so I think it's good to get some exposure to this early on so you have at least a flavor of what a patent is and what intellectual property issues are going forward. So what I'd like to do is first give you an overview of the patent system, what a patent is, what it isn't, how you get one, and then I'll give you a few examples from my own experience of certain patents that have come out in recent years, and then I'll give you an idea of what I do every day as a patent attorney. So let's start with the basics. What is a patent? It's actually a legal document that's issued by the U.S. government that gives the patent owner the right to prevent others from making, using, or selling the invention that's the subject of the patent. I emphasize that it prevents others. It's a negative right, and I'll explain a little bit more about that. But what it does is it gives you the opportunity to prevent others from making, using, or selling the invention. And basically, there's a quid pro quo between the patent issuer, which is the government, and the patent owner, in that the government will give you a limited monopoly, that is to say, the right to prevent others from making making the invention for a limited time. It's not forever, it's a limited time, in exchange for a complete description of how to make and use the invention. And that's, as we'll talk about, that's one of the main requirements for getting a patent these days. The idea here is based in public policy, really, is that the idea of the patent laws is to encourage innovation, and putting more information out there for everyone to use and see is a good thing and allows people the building blocks to force the technology forward. So the authority for granting patents comes directly from the United States Constitution. It was actually put in there by Thomas Jefferson, who turned out to be, just a piece of trivia, he turned out to be the first commissioner of patents, and he was also the first patent owner. So the language in the Constitution that applies to this says that Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this talks about patents, and it talks about copyrights because it refers to writings. But just a couple of things here. It says, promote the progress of science and the useful arts. That's sort of that's the incentive part. By securing for limited times, and we'll talk about that. It's not a forever right. It's a limited time to inventors the right to their discoveries. And so what is fostered from this is a whole industry that is directed to acquiring patents. And the Congress has promulgated rules and regulations about what a patent is, and we'll take a look at one. But basically, it's a lot like a scientific paper. There's an abstract, a specification, which includes the background, a summary, a detailed description, and drawings, and what are called claims. And the claims are the numbered paragraphs at the end, which I'll show you in a moment. But they're the most important part because they really define what the invention is. And in the biotech space, where I spend a lot of my time, there's also a sequence listing for biological sequences for proteins, nucleic acids, that kind of thing. So here's an example of a patent This is one I got a number of years ago for what's that Ivy League school that's over across the way here? Oh, yeah, that's right. But this is the first page of the patent, and basically it has just a couple of features. Here's the patent number up here, and the date it was issued back in 2003. The title of the invention, which is a catalyst for aromatic bond formation. The list of the inventors. The owner of the patent, which is Yale University. So it's not the inventors that actually own this, it's the university. Some serial number information, identifying information from the patent office. A list of references. These are all the publications that were cited to the patent office when it was being examined by the patent office. And then there's the abstract, which just gives you a brief flavor of what the invention is. So there's a lot of information on the face of the patent. So this is the example of a claim that's in this patent. And like I said earlier, the claims are the most important because they really define what the legal metes and bounds of what the invention is. And this one is directed to a transition metal catalyst having a group 8 metal, which happens to be this iron, and a ligand having this kind of funky diaromatic structure. And we have certain R groups here, and all of these R groups are defined. So that's the scope of this invention. It's directed to this particular catalyst having all of these kinds of variables. And then we have other claims here that further define what the variables are. And so as you read through this, you can get a real picture and a big flavor for what the scope of the invention is. So I mentioned earlier that the patents don't last forever. They have a limited time, and right now they last 20 years from the filing date. The Congress has determined that 20 years is a long enough time for the owners to exploit their inventions. And once the patent is, the 20 years is up, the information goes into the public domain where anybody can make and use whatever's claimed in the patent. The inventors, who in this case were three professors, 3 people at Yale, the inventors are by definition those who contributed to the claimed invention. That is to say, they invented what's here in this claim. They're not technicians, not people running computer programs in the background. They're not people that are just running HPLC. But they are actual people who actually thought of this particular invention, and that becomes an issue later on because sometimes you do run into, I was an inventor. No, you weren't an inventor. I was an inventor. These inventorship disputes. The law has recently changed with regard to who is awarded a patent. Up until about 2013, it was in the United States, whoever invented the invention first was awarded the patent. The United States, on this particular first to invent system, was sort of an outlier. The rest of the world was on what we are on now, the new law, which is the first to file system. Basically here, you filed your application, and if someone filed a day later than you, it doesn't matter if they invented it first, you filed first, and so you're awarded the patent. So now it's a race to the patent office with these inventions. So the American Invents Act is the law I've been referring to. It was enacted in September of 2011 and took effect in about 2 years ago in March of 2013. The first entity to file the application is entitled to the patent over those who file later on the same invention. And as I said earlier, it's basically a race to the patent office. So what I've seen in the intervening 2 years is there's a lot more filings going on. People are just filing like crazy, trying to beat any kind of competitor. So it's been good for business so far. Anybody have any questions so far before I turn to subject matter? Yeah.
If a person, for example, puts in a pending patent, and then he has a friend who he says, okay, I want you to create the same patent, submit it, and we'll both have them pending, have like perpetual patents, let's say, so that it would never expire. Is that allowed?
Well, a couple issues with that. First, there will, if it's for the exact same invention, there's going to be, the patent office will probably see that and say, whoa, there's two people are inventing on different applications for the same invention. And they'll declare what's called an interference, which is basically a procedure that determines, who invented this thing first. If they filed on the same day, you're going to run into problems because you can't have two patents on the same invention. So I don't think, whatever scenario you're talking about, I don't think, ultimately it's not, it has to be resolved somehow. You can't have two patents on the same invention. Yeah?
Before the patent went to the first to file, how did they determine who invented it first?
It was through the, well, if you had two applications with the same subject matter, the same invention, but one had inventor set A and the other had inventor set B, they try to determine who invented it first, and you do that with what I just said through this what's called an interference proceeding, which basically is, it's almost like a judicial proceeding where you have to go back and produce your notebook records and all the paperwork that came before you filed the application to see who actually came up with the ideas first. I've been involved in several of these, and they're very, very time consuming and very, very detail oriented, especially among academics, who keep a lot of notebook records. But that's basically how you do it. The patent office would call for an interference. They'd say submit evidence on when you started to invent this thing and when you came up with the invention, and then they'd make a decision. Yeah.
If I get a patent on something in the US, do I automatically get one internationally, or should I buy it for someone?
Yeah, we'll talk about that in a little bit.